The meeting of the Health Insurance Reform Commission will now be called to order. I want to call the roll.
Delegate Bourne.
Present.
Delegate Geditis.
Present.
Delegate Ware. Senator Saslaw. Senator Surville.
Here.
Senator Spruill. Secretary Walker, represented today by Assistant Secretary Pleasance.
Present.
Commissioner White.
Here.
Vice Chair Heretic.
Here.
Mr. Chair Barker.
Here.
Mr. Chair, you have a quorum.
Thank you. And Senator Spruill is on his way. He got caught in the backup down in Hampton Road, so he's on his way and will be here hopefully shortly, so not before too long. So anyway, we have a couple of things I want to do today. First one is dealing with the presentation on state defrayal of cost of mandated benefits, which is not an insignificant issue. All right. All right.
Good morning, Mr. Chair and members of the Commission. Are you ready for me to speak?
Yes, please go ahead.
Okay. All right, and I'm not sure, I guess I'm sharing my screen, is that right, for my presentation?
That's correct, Julie.
Okay. All right, is that viewable to everyone?
It sure is. Go ahead.
Okay, all right, great, thank you. My name is Julie Blauvelt, and I'm with the Bureau of Insurance. And I want to thank you for allowing us to come today to discuss an issue that is not a new one, but it is getting some new attention. So today I'm going to give you a little background information on the requirement of states to defray costs of state mandates that are deemed in addition to essential health benefits. And I'll talk about the review that the Bureau of Insurance has done to get ready for a new report that CMS is requiring in July of next year that will require states to report on these state mandates. And we'll take a look at the formula and enteral nutrition mandate specifically that was passed, and it was effective this year because we've identified that this benefit potentially could require a state mandated defrayal of costs. And I'll talk about a separate concern that CMS has raised with us about Virginia law that segments a market where qualified health plans are prohibited from providing benefits, but non-qualified health plans in the same market are still required to provide those benefits. And when I say qualified health plans versus non-qualified health plans, a qualified health plan is one that's offered through the exchange, and non-qualified is one that's offered solely off the exchange. And then we want to present the Bureau's position on the actions that we're going to need to take related to the information that I'm presenting. And then lastly, we'll look at some options for possibly HERC to consider if you want a different outcome that's going to result in something different than what I explained will happen with the Bureau taking the position that it's going to take. I just want to talk briefly about the basis for the discussion today. So when the ACA was formed, it created essential health benefits, which are a minimum set of benefits that all ACA plans that provide individual and small group health insurance coverage have to include. Some of the essential health benefits are mandated benefits, and some of the essential health benefits are not mandated benefits. In order to establish each state's essential health benefits, the federal government, way back in 2012, required states to choose a benchmark plan initially. Virginia chose the most popular small group plan as its benchmark for the first benchmark plan in 2014, and then we were required to choose, again, a benchmark plan for 2017, and that's the one that is in effect now. Once the benchmark plan was chosen, that established the essential health benefits for the state. And those essential health benefits can't be changed unless CMS is notified of the change and the state follows rules in order to make that change. And for example, one of the rules is that there's a limit on the richness of benefits that the benchmark can provide. A state can require plans in the individual and small group market to provide benefits that are over and above the essential health benefits by mandate, but the state has to pay carriers to cover the cost of any of those mandates that are in addition to essential health benefits. And CMS was concerned that states weren't reporting new mandates and weren't defraying costs of new mandates. So these federal rules were put into place to report all benefit mandates by July 1 of next year and annually each after that. And that report is supposed to identify the benefit mandates that are in addition to the essential health benefits that require defrayal. Okay, and when the report was required, this is when the Bureau's understanding of what was considered to be in addition to EHB changed from its previous understanding. And so we are working through, together with CMS, the information to complete this report on the state mandated benefits. And we've been talking with CMS to get their thoughts on different situations where mandates are in addition to essential health benefits. And we've used specific examples about existing state mandated benefits and potential state mandated benefits that this commission is looking at, like prosthetics. Prior to this report being required, there really wasn't any follow-up from CMS to check on the determinations that states were making on these new mandates. And it's important to keep in mind that it is still the state who is responsible for making the determination as to what is in addition to EHB. So when the Bureau of Insurance did its analysis for HERC about, and when it does an analysis for HERC about whether there's going to be a cost to the state related to a proposed mandate, and in particular when we looked at the formula and enteral nutrition mandate that was effective this year, there was a question in our minds as to whether that would be in addition to essential health benefits, since it is a new mandate. But the enteral nutrition benefit was already in the essential health benefits, so it didn't really seem plausible to us that by mandating, clarifying something of that benefit, that would then become in addition to EHB and kick it out of being an essential health benefit, basically. So we consulted the National Association of Insurance Commissioners, the NAIC, and we sent the specific scenario of the enteral nutrition mandate benefit for their guidance when we were asked by HERC to give our analysis of whether the benefit would be in addition to EHB. We explained to the NAIC that the benefit was already in the state's benchmark plan and it was just being expanded. And the NAIC came back to us and said that states could successfully argue that a mandate that was related to something that's already in the EHB, even if it is a new state mandate, is just a clarification of an existing EHB and not an additional EHB. So that was the petition. That was a position that we took, the Bureau, in our analysis of the benefit when we gave our analysis to HERC of the enteral nutrition mandate. But in July of this year, in preparation for this report that we need to submit next July to CMS, and the conversations we had with CMS, we were surprised to find out that CMS does not accept that argument and holds strictly to the rule that any mandate that's enacted after 2011 is in addition to essential health benefits, even if the benefit was already in the benchmark plan in some form. Of course, we always understood prior that any brand new benefit that was never in the essential health benefits, if it was newly mandated, that was going to be in addition to essential health benefits. But we didn't fully understand until this conversation this summer with CMS that an existing essential health benefit, if a mandate is changed and that benefit is changed in any way, or if there was no mandate prior to, like the enteral nutrition benefit, and then we have one after 2011, that it is no longer an essential health benefit. So we have that new understanding now, and so the Bureau of Insurance asked for a chance to come to the Health Insurance Reform Commission to share this information and present to HERC what the Bureau is going to do about this new information, and present some legislative options that HERC might want to consider to possibly change the outcome of what the Bureau's position is. So the Bureau of Insurance did take a look at all state mandates that are in effect in order to get ready for this report. And in light of our new understanding, and as you know, we have had several bills that relate to health issues since 2011, but not all of these need to be considered new mandates, because if they are put in for technical corrections, or to talk about the method of delivery, like telemedicine, CMS indicates that that is not something that needs to be considered in addition to EHB. Also, if a mandate is put in order to comply with federal requirements, like the ACA or MAPIA requirements, mental health parity, then that is not considered to be in addition to EHB either. We've also, that's the second bullet under the, we've also had some bills come through that mandate certain types of providers or cost sharing requirements, and those are specifically stated by CMS that those will not be in addition to essential health benefits. But we did find out, as I said before, in talking with CMS, that the formula and enteral nutrition mandate that was effective in 2021, this year, beginning of this year, should be recognized as in addition to EHB. So it's also important to keep in mind that once we submit this report in July of next year to CMS, there could be some other interpretations that CMS says, that they consider to be in addition to EHB that we have not flagged. So talking about this formula and enteral nutrition benefit specifically, this is a look at how the benefit changed from what it was in the original benchmark plan to what it is now under the new mandate that was effective the 1st of this year. So the original mandate, what was in the original benchmark plan, covered infusion services, including enteral nutrition therapy and infusion of special medical formulas, as the primary source of nutrition for persons with certain inborn errors of metabolism. And the new mandate covers all inherited metabolic disorders, formulas that's taken orally, not just enterally, and formula required as a critical source of nutrition, but not the primary source of nutrition. So like we've talked about, even though this benefit was in the EHB since the beginning, because of the new mandate that was effective this year, CMS indicates that would make it in addition to EHB. We did look at a very preliminary estimate of what the cost to the state for this mandate would be if the state was going to need to defray costs for it, which would range from about $350,000 to $700,000 annually. So, and that's not the entire story, because in Virginia there's another nuance to the state mandate and state defrayal determination. Virginia does have a law, 38.2-6506A1, that tries to protect the state from defrayal costs by saying that QHPs are prohibited. So these are plans that are offered through the exchange, are prohibited from providing a state mandated benefit that's not part of the essential health benefits. So looking at the enteral nutrition mandate, that always has been an essential health benefit, but now with the new state mandate that we understand now suddenly removes the benefit from being an essential health benefit under federal rules. This law now says that the mandate's no longer an EHB, and so QHPs, plans through the exchange, are prohibited from providing the new benefits or any formula and enteral nutrition benefits, which does save the state from paying defrayal costs. It may save the state from paying defrayal costs, I'll say it that way. And I say may because there is an issue with the protection provided by this section of the code, because CMS says that this type of market segmentation, where you have benefits required of some plans within a market but not all plans within a market, is discriminatory. And federal guidance does say that the way that this concern is remedied is when there is a difference of benefits where non-QHPs, off-exchange plans, are required to provide a benefit and on-exchange plans are not. Then the state has to require all QHPs and all non-QHPs in the same market to provide the same benefits. So if that did happen, where QHPs are required to provide the new mandated benefits in accordance with what federal law says, then that would require the state to defray costs. And this issue isn't really, the market segmentation concern is not really a new issue to us. We have been including this determination by CMS, this market segmentation issue, in comments on legislation. And indicating that it does open the door to federal preemption and potentially state defrayal, but I'm not really aware that this has been tested in any state, or that a state law of this sort has been preempted by federal law in any case. But we did ask for information from states, and we got a few responses back about how they address this issue, and I'm going to share those examples in a minute. So right now I'll talk about the Bureau of Insurance's position on the enteral and formula and enteral nutrition mandate in particular, and the information that we've talked about. And so we feel that this mandate for 2023, unless laws are changed prior to that time, since this benefit has been an essential health benefit since the beginning, and it's now deemed to be in addition to EHB because of this recent state mandate, and CMS's determination about that is clear, that it's a new state mandate and is in addition to EHB. The Bureau of Insurance position is that effective for 2023 plans, that we will follow what's in Virginia law under 38.2-6506A1, and QHPs in the individual and small group markets would be prohibited from providing this formula and enteral nutrition benefit that is no longer in the EHB package. If we were to allow the mandated benefit to be provided contrary to this Virginia law, then it could mean that the state would need to defray the entire cost of the benefit. And we know that wasn't the anticipation of the General Assembly when the mandate was passed. There is still a possibility that the state could have to defray this benefit for 2022, but we felt we didn't really have an option to make the change to prohibit the benefit for 2022 because at the time that we got this new information, the 2022 plans were well under way for approval, and we weren't able to make that change. And we know that prohibiting plans, QHPs in 2023, from providing this benefit will segment the individual and small group markets, which could still result in state defrayal if the federal law preempts Virginia law. But we feel that the Bureau can't make the determination not to apply the state law. So given all this, here's a little chart of some things that HERC might want to recommend, might choose to recommend for legislation so that a different action could take place in 2023 for this benefit, and also to consider future mandates as well. And of course, there's, I'm sure, more options than I've put here, but this is just kind of to, start the conversation and start thinking about this. So going through the chart and focusing on what the desired outcome is. On the first row, if the desired outcome is that all plans in a market would provide coverage for state mandates, no matter if the state defrays the cost or not, then HERC might want to recommend that there is a change to that 6506A1 and other laws that tend to segment the market to remove the prohibition against QHPs from providing benefits. On this one, I'd note that the state would be required to defray costs if all qualified health plans in a market are required to provide this coverage, but it does eliminate the discrimination issue. In the second row, if the goal is for the state not to defray any costs at all, the only way really to ensure that is to remove the discrimination question for the past mandates and to not impose mandates in the future that require defrayal for the individual and small group markets. So HERC could recommend that mandates that require state defrayal only be applicable to plans in the large group markets or Medicaid or state employee plans. But of course, mandates on Medicaid and state employee plans most likely do come with their own cost to the state. Sorry, didn't mean to move that. So with this action, most of the fully insured market would be required to provide coverage through the large group plans without defrayal costs to the state. And it could solve the current problem of the enteral nutrition mandate as well, and going forward, if that's the desired outcome. So if changes are made so that the new formula and enteral mandate no longer applies to the individual and small group markets as a whole, what would happen is the benefit would go back to the original benchmark enteral nutrition benefit. And that would apply without state defrayal if the mandate was taken out of the individual and small group markets, if the new mandate was taken out. So looking at the third row, there is a way to add benefits in the individual and small group markets without state defrayal, and that's through making changes to the essential health benefit benchmark plan. This isn't really a quick process. It takes about 1.5 years before changes are effective, changing things this way, but and there are rules to how you can change and restrictions and guidelines and on how you can make changes to the benchmark plan. And the benchmark plan doesn't apply to large group plans, so just making the change to the benchmark plan wouldn't provide coverage across the market as a whole, across all fully insured plans as a whole. And also it's important to note that changing the benchmark plan doesn't relieve the issue of if there is a mandate that's in effect that the state has to be defraying costs for, we still would need to do something with that mandate to make it no longer apply, because even if it's a new mandate after 2011, there's going to be cost to it, even if it is in the benchmark plan, as we've talked about. And then market segmentation could still remain an issue with changes to the benchmark plan if other changes weren't made. So in the last row there, if the goal is to remove the concern about segmenting the market, then amendments could be made that affect the current section that allows for the segmenting of the market. So if the change takes away that prohibition to provide a mandate that could cause defrayal, then that removes the state's safeguards against state defrayal. But you could instead do the opposite and prohibit the benefit from all plans in the individual and small group market. And an example of this is on the next slide. And these are examples of when we talked with other states that have made some changes based on the CMS rules about segmentation and about new state mandates. Both Texas and Nebraska have laws that safeguard the state from defrayal costs and that guard against a segmented market. But instead of how CMS said that the default would work if a market is split, if a law would apply that would cause the state to have to defray costs, and therefore the state would say it doesn't apply to QHPs, then they make that mandate not apply across the entire market, individual and small group markets. In New Mexico, they only apply new mandates to the large group market Medicaid or state employee plans. And they look at whether they want to change the benchmark plan to apply any benefits to the individual and small group market. And then Maine just kind of has a process like what we've already got as far as the Health Insurance Reform Commission process, but they've not adopted any new mandates or expanded any state mandates since 2011. Oops, so I know this has been a lot of information and just some kind of parting things to keep in mind about this information. And I think the overall theme of this slide is the uncertainty of what CMS will continue to require going forward. There is always a possibility that the CMS requirement to make this report of state mandated benefits, what kind of started this whole string of events, could again be deferred or delayed. It was originally required to be reported in 2021, and with new federal rules and kind of the change of the Trump to the Biden administration, that the reporting of state mandates was deferred to July of next year. So there's always a possibility that it could be deferred again with the annual rules that are put out. It's important to remember that states are the ones that make the determination of whether a benefit is in addition to EHB. And although the determination is supposed to be made in accordance with federal rules, and we don't really know what happens if a state and CMS disagree on whether costs should be defrayed. CMS is aware of Virginia's laws that do segment the market and hasn't yet acted to preempt these laws as discriminatory. And CMS hasn't indicated that there will be retroactive penalties assessed if a state did not defray costs when required. But there were rules that were issued just recently that did mention that HHS could rescind up to 1% of payments due to a state until the state takes corrective action toward compliance. And there's always a possibility that actions, however we react to this new information, will make a difference to how CMS handles any penalty decision. We do continue to have discussions with CMS about state mandates and potential state mandates. We're actually in discussions now about the autism mandate that was enacted in 2020, and those discussions are ongoing with CMS. We feel that this requirement is not a new requirement to cover autism. That coverage of autism was a state mandated benefit prior to 2012, and that changes that were made in 2020 to bring it into the individual and small group markets were done to comply with MAPIA, but we are still in discussions about that. So to sum this all up in just a few bullets, based on the new federal reporting requirements that we'll have to report next year and the Bureau's new understanding of the federal interpretation of the rules, the Bureau will prohibit qualified health plans in the individual and small group markets from including any formula and enteral nutrition benefit in 2023 plans that are filed in the spring of 2022, unless there's a change made to Virginia law. This will not apply. It will segment the market. It won't apply to the plans that are solely off exchange in those markets, but there could be a potential for state defrayal because of the segmentation that's contrary to federal rules. Most plans in the individual market are QHPs offered through the exchange, and most plans in the small group market are non-QHPs offered off the exchange. So as we discussed, there are some options where HERC may want to recommend some legislative changes to change what will happen with this mandate and the future mandates. That's my presentation. I will take any questions.
Yeah, thank you, Julie. That was certainly a thorough presentation. I'm not sure how quickly we're absorbing all of this here. Seems like there's a lot of different ways in which this could be implemented in whatever process we have with the CMS. Are there questions or comments that members of the commission have?
I have a question.
Senator Erble.
Thanks, Mr. Chairman. I think for a presentation like this, it would be really helpful if we had some context at the beginning of it so we understood exactly which sort of segment of the market we're actually talking about. Because, I know that, for example, there's obviously Medicare, Medicaid pick up a certain percentage. The state employee health care plan has a piece or whatever, but I have no idea. I haven't seen data lately about what's large group, what's small group, how many are an individual, and exactly what we just heard about, which parts of it affects. And so there was a lot of context lacking, trying to process the information, trying to figure out which people we're talking about in terms of making a decision. So I just think if staff or somebody could get us that information, for those of us who are new to HERC, it might be helpful info to have so we know exactly what we were just talking about. Like, I don't know how many people we're talking about, how many businesses, how many plans. That might be useful information to process that. So it's just a comment on that. But, I mean, I think I kind of understand the conflict we have, but some context would be useful because I think there's a lot of assumptions built into that we all understand a lot of this stuff when some of us are new to this.
All right. Other comments or questions? Well, just a question. Do you have any sense as to whether there is a path that would require defrayal of what was new but not defrayal of the entire benefit, since the rest of the benefit was already in place prior to 2012?
Well, yes, that is, that was a question that we had of CMS, but CMS did indicate to us, since there was no existing state mandate for that benefit, that the entire amount of that benefit, not just the new portion, would need to be defrayed. If I could, I can try to address Senator Surville's questions about the amount of people that this would represent. In the individual and small group markets, which is where the problem lies, and that the individual market in particular is changing every day. But it's about, I would say, 350,000 maybe right now in the individual market. And the percentages of the individual and small group market of the entire Virginia population, they're pretty much the same, about 4% is individual market and about 4% is small group market. And then the large group market, I think, is about 14% of the Virginia population. Like I said, most plans in the individual market are plans that are offered through the exchange or are qualified health plans that could be offered through the exchange. And most plans in the small group market are not qualified health plans. But if a market is segmented, then you could have a defrayal issue across the entire market.
And just to sort of round out the percentages there, the largest share of insurance is ERISA plans that are plans where companies have contracted directly with an insurer to be able to write the plan for them and have that rather than, and these are exempted from any mandates or anything else that we're dealing with here. So there's a large share of the population that is covered under these ERISA plans and is not impacted in any particular way there, other than if the state has to pay defrayal. So any other questions on that? If not, you're right at the moment. Do you have any idea as to, depending upon a final determination of the autism change that took place with the 2020 action, do you have any indication of what that might cost to defray if it were just for the markets that were affected by that change, or if it were for the whole population?
We have not done an analysis of that because this is very new information that we just got from CMS that they, and we're still, not at all in agreement with CMS right now that this would be considered in addition to EHB, and we are still working with them. And like I said, I don't know, it is the state's determination of what is in addition to EHB, but we do need to submit this report, so I'm not really sure what occurs when there's a disagreement. HHS does have the penalty option, but I think it's just working together to try to come to a solution. And I do know that, so I guess it's not totally set what benefits would be considered to be in addition to EHB, because we don't at this point know what part of the mandate CMS would indicate would be in addition to EHB.
Well, if I recall correctly on that 2020 action we took, it did not change what was required to be provided. It just affected the small and individual markets there rather than whereas previously it had been just a large group market. Is that correct?
Right. Previously, the mandate, yes, it was only effective for the large group market and then expanded to the individual and small group market. Our position is that autism was always a covered condition under the essential health benefits, and that goes back to the initial sections 3412.1, the required coverage of mental health benefits for all fully insured plans. And then there was also a biologically based mental illness requirement that did require coverage of autism as a biologically based mental illness. So we are trying to indicate to CMS that autism, the condition of autism, was always a required benefit, and that the additions that were made to the requirements of the individual and small group market with the new mandate in 2020 are really to comply with MAPIA. And CMS has told us that they think that Virginia defines autism as a mental health condition. So that stands to reason that the mandate that was put in force in 2020 was done so to comply with MAPIA, which is an acceptable mandate for a state to put forth, where a state doesn't have to defray costs.
Okay, that would be helpful there. So, any other questions or comments? What I would suggest then is that we cogitate on this and come back at our December meeting and try to have some options before us presented that we could review in advance of the meeting, so that we can weigh those options and figure out sort of what we want to recommend moving forward in the 2022 session. Any further discussion or questions on that? All right. Well, we will proceed in that fashion then, and thank you very much, Julie, for the presentation, and we'll have you on the line again next time, then. So thank you.
Okay, thank you very much.
Certainly. All right. The next item and the other significant item we have on the agenda is the issue of the discussion of the couple of bills that Senator Peterson had introduced and that were referred to the commission. We've discussed this a little bit in a previous meeting and want to sort of get into it in a good bit more depth now. And Senator Peterson was able to come down today and make a presentation on it. So we will start with that and then figure out sort of how we go from there. So.
Okay. I see some looks in the crowd that didn't know I was making a presentation, but first of all, it's great to be here in the flesh. Right. This was Senate Bill 867, and I carried this on behalf of some advocates. This is the vertical integration bill, and the legislation we've had for years, and Senator Spruill knows it well, comes out of the Chesapeake, Southeast Virginia part of the state. Basically, it deals with vertically integrated carriers, which is where you have a hospital system that owns its own insurance network. And That's most applicable in Southeast Virginia, where you have Centera that owns Optima, and how basically it deals with other healthcare providers in that area, particularly if they have a monopoly share of the market. There are really two aspects, and by the way, I hadn't really thought about this. I was glad you put me second on the agenda because it actually gave me a chance to go back and read the legislation for the first time in 30 months. But there were really two aspects to my legislation that were critical. One is this concept of any willing provider. That is, if you have an insurance network and they're controlled by the hospital system, rather than simply feed the patients, feed the customers into their own hospital system, they have to cover services that are given by any willing provider, any willing qualified provider, and we have definitions for that in the legislation. And that's simply so those patients that want to go to Chesapeake Hospital, they want to see their own doctor, they want to go to physicians or hospitals that are in the community or that they're comfortable with, that they will still be covered even if they have Optima Health insurance. Secondly, in this concept of no overlapping leadership, and that's basically that you can't have the same CEO, you can't have the same board of directors, even if it's a wholly owned subsidiary or a wholly owned, and these are nonprofits, by the way, so it'd be board of directors is how they'd be governed, that you cannot have overlapping leadership. They have to be separate and independent. And that's, economists have gone back and forth about this idea of vertically integrated industries and whether or not it's more cost competitive, whether or not it's more efficient. And I know a lot of folks, particularly in, say, the Chicago School of Economy, think vertically integrated industries are more cost efficient. I think the statistics actually show otherwise. And I will look at a presentation that I got, which simply said that, in general, in the Hampton Roads area, the Virginia Beach market, which was roughly that 757 area, was 14th highest out of 124 cities surveyed in 2017 for healthcare costs. So it's at the front, at the top of the healthcare costs, and that is considered largely a vertically integrated market because of the presence of Centera and Optima. So I don't want to spend a lot of time. There's people behind me that know a lot more about this issue than I do. But I did want to come down here in person because it is an important issue. I think it does have statewide ramifications, and I think it's a good consumer bill. Thanks.
All right. Are there any questions of Senator Peterson?
I will almost certainly phone a friend if there are. So.
Okay. All right. Any comments anyone wants to make at this particular time? All right. Well, we will then proceed to open up for discussion on things, but to keep it a little bit informal today. And what I would say is that I think that what's directly in the bills that Senator Peterson has presented is dealing with issues where there could be impacts from a vertically integrated company if they took certain actions that would be negative to participation or to equal participation within markets that would be the insurance market, be the hospital systems, as well as the providers, the individual physicians and other providers. And I think it's more important for us to focus on that rather than the question of how do vertically integrated systems compare in terms of quality and cost and those types of things. That's more of a market determination from my perspective, and is something that we're not going to be able to change that. So there's no point in getting into an argument as to whether vertically integrated systems are more cost effective or less cost effective, and what the implications are in those situations. But I think it is important that we deal with look at the issues there as it relates to the access that patients have, that physicians have, that hospitals have, that other insurers have in the market, and make sure that there is fairness and equity in that process.
Mr. Chairman.
Yes, Senator Spruill.
I'm trying to, if Senator Peterson will come to the, I'm looking at two issues.
Yes, sir.
The main one I'm concerned with as far as that if an insurance company has insurance through the hospital, then I do agree that others who have insurance company should be able to use the insurance company as well.
Right.
What I'm having a heartburn with as far as the board of directors.
Okay.
So let's suppose, so you're saying that, let's take your board, your company you work for, you have a board.
Right.
So you are saying that you cannot put your folks on that board of directors, that it has to be somebody like me who is an outsider? I don't understand why Centura, for example, can't have their own board of directors. I'm trying to understand about that part.
Okay, well, I don't, may I respond, Mr. Chair?
Yes, Senator Peterson.
I have no objection. If Centera can have their own board of directors, I don't care. My point is that the board of directors for Optima, for whomever the insurance carrier is, has to be different. Now, who those people are and what criteria they use, that's up to this committee. I have no concern with that whatsoever. I just would prefer them to be separate, so their books are separate, their agendas are separate. They're not being run by the same folks.
Mr. Chairman?
Yes, Senator
But
Sproul.
Optima is Centura.
Well, I know
Pretty
that.
much.
That's the issue. I mean, that's the problem.
Okay, all right, thank you. Mr. Chairman, to you. I'm
Yes, Senator Sproul.
I thought my hair got messed up into something. Mr. Chairman,
Either that or your suntan.
Mr. Chairman, I want to just deal with it as far as I'm concerned about, I'm concerned about other insurance company, health company will be able to participate into that Optimus, that hospital. But as far as the board of directors, I don't see no need to mess with that. But I do have a problem with not allowing, let's say, Chesapeake or in other hospital to participate into the Optimus system. That's my objection. Thank you.
Mr. Chair, if I could respond. Look, I'll take, if that's what you like, Senator Sproul, then that's what we're going to go with. Again, there's different aspects, but any willing provider is, I mean, that's the meat of the bill.
Okay.
Yeah.
All right, thank you.
All right, are there other questions or comments from members of the committee? All right.
Mr. Chairman, I have just
Yes,
a process
Senator
question.
Zerble.
So I have two bills in front of me, 474 and 867. I'm just trying to understand which one we're actually dealing with. Or both.
I think 867 was the 2020 bill. I think that's the more recent or most recent iteration. Yes? Yeah. So 867 is what we're working off of. That got what's got referred.
Mr. Chairman, Senator Serval, Senator Pearson, they were both referred, you introduced both in the
Oh, I did?
2020 session. I believe you introduced one inadvertently,
Just shows you how careful I am of my
but
legislation. Yeah.
they were both
All right, which one
referred
y'all
to
like
the
better? You take
commission,
'em, huh?
so take your,
I'll take 867 because I just read that 20 minutes ago on my phone. So, all right.
Yeah, I think that actually was the one that was considered and referred to her, was 867. But the major difference I see just in terms of the heading on it is that 474 was pre-filed and 867 was pre-filed on January 7. 867 was January 8. So, it's one day later. So,
Mr. Chairman.
yes, Senator Serval.
So, in light of the colloquy I heard, I think what we need is a motion to strike lines 174 to 77 from the bill for purposes of our recommendation, but I'd like to hear a little more discussion about that before we,
Yeah.
I don't know if I need to make the motion and have it seconded to tee up the conversation, but I think that seems to be a decision point for at least one of our members. So I guess I would move to do that, and Lionel probably would want, or Senator Sproul would probably want to second that.
Well,
Okay. And then we can discuss that.
let's just discuss it if anybody wants to discuss it here now, and then this has it on the table, and then we'll go on to get other input in the process before we move on, take any action on anything. So, all right, any anyone want to address that issue? All right. Well, what we're going to do is open it up for public comment now and have people be able to make statements on things and move, to get everything on the table before we figure out sort of how we're going to work through the process here.
At this time, anyone who's in the room and wishes to give public comment in person, please line up in front of the lectern.
Mr. Chairman, would these comments be on the motion, or would it be on?
Mr. Chair, so for clarity, that'll be just members of the public who wish to comment on the motion before the commission. Thank you.
Which, just to make sure I understand, we're talking about Senator Servell's motion to strike lines 174 through 177 regarding separate boards. Mr. Chairman, members of the commission, I am Curtis Bird, Director of Advocacy with Chesapeake Regional Healthcare, and thank you for allowing me to speak on this, specifically with regard to the issue that Senator Servell's motioned. The whole purpose in this is to make sure that there is a firewall where each entity, you have the provider side of the firewall is focused on what it does, and the payer side on the other side. And where there is not a firewall, there is a risk of the payer cross-communicating and coordinating its business model with and by the direction of its parent company. So at the end of the day, the payer should have as its number one focus its members, its subscribers, not its parent companies or its parent company's balance sheet. So we're simply suggesting that it doesn't matter who serves on those boards. We simply believe that those individuals need to be separate and that the commingling or the blending of their two governance models would be separate. So that's the purpose of having that provision in the recommendation from the white paper. Thank you.
Mr. Chairman, I have a question.
Senator Serval.
Thanks. I have a question for the speaker. So, Inova also has one, would qualify as a vertically integrated carrier under this, right?
No, Mr. Chairman, Senator Serval, no, it would be based upon how it's defined in the bill. And if you look at 867 and how it defines vertically integrated carrier, it talks about, well, actually in 867, it simply means has common ownership or control. So I think what's important would be to further define in the legislation potentially what ownership means, what control means. So I know in previous versions of the bill, I believe there was a 10% ownership threshold. There's been talk about changing that, but perhaps the Bureau of Insurance might even have a position on how it would deem ownership and control and how those two would play out in terms of defining what a vertically integrated carrier is for the purpose of this recommendation.
Mr. Chairman, further question?
Yes, Senator Serval.
But so I don't understand how Inova is not in, because they have one of these plans too. Can you just give me some color on why they're not in?
Yeah, I believe it's a 50, again, Mr. Chairman, Senator Serval, I believe it's a 50-50 joint venture, whereas other vertically integrated carrier systems in the Commonwealth have different ownership structures. For example, Virginia Premier, I think there's an 80% ownership structure. I think Piedmont has different out in the Lynchburg area. Optima, obviously. So again, I think it would come down to defining a little bit more clearly what that is so that a 50-50 joint ventureship would not have potentially any impact from this legislation.
Mr. Chairman, further question.
Yes, Senator Searle.
Thanks. So amongst, I guess, the other plans that are like this but not included in this definition, do those boards have any cross-pollination between the governing boards?
Mr. Chairman, Senator Servell, I have.
Because I'm just trying to understand, like, what if it's good for this particular, if this policy is good for this situation, why it wouldn't be good for the other plans that are out there that have not 100% ownership, but 50 or 20 or whatever, right?
Mr. Chairman, Senator Servell, as of today, I couldn't give you an answer that I would say with certainty is the case, but I think that what this recognizes is potential for something to go wrong, something nefarious perhaps, and by putting this sort of a limitation or guardrails on these types of business structures, that it would be a stronger protection towards consumers in terms of how these entities are governed and how they're protected in terms of taking direct direction from their parent company.
Mr. Chairman,
Yes, Delegate Goditis.
question, Mr. Chairman. Have there been known problems? How long has this arrangement stood, and are there known problems with this board of directors?
Mr. Chairman, Delegate Goditis, I can refer back to a couple of years ago when this issue was really first coming before the General Assembly. There was a meeting between parties, legislators, stakeholders, and in that meeting, it was stated by the head of Optima that it, at the direction of its parent company, Centera, it was not permitted to include in its network non-hospital affiliated ambulatory center outpatient facilities. So that's why this kind of struck us as being, wow, so you're taking direction from your parent company, not operating independently through the direction that your board gives you, through your own governance and leadership gives you. So that's why this was put in there, to really guarantee that there's no, so for example, if someone goes into Optima or has Optima and they go into a Centera facility, are they then open to getting direct contact by Centera for further services that it might offer? How would Centera have access to the information of that consumer if it were not that the insurer is providing that information directly to its parent company? So we're just trying to create some sort of firewall to make sure that there is an independence as to how these businesses operate, and that the insurance company should do what's in the best interest of its members, and again, not necessarily what's in the best interest of its parent company.
Mr. Chairman, a question for the speaker. I think what you're describing, at least as I'm hearing it, amounts to interlocking directors. I think amounts to essentially potentially price fixing. I mean, I think what you're describing here is an antitrust issue. Aren't there already remedies, at least under federal law, for the problem that you're describing?
Mr. Chairman, Delegate Heretic, I am not a subject matter expert on antitrust, but it would appear to me that there are those provisions. Senator Peterson, I think you can probably speak to antitrust.
Well, it's interesting. I had an antitrust case. Okay, I thought you were shutting me down, Sean. Okay. You were like under instructions. Okay. The issue as to whether or not vertically integrated can qualify as a monopolistic practice, it's what's known as a Section 2 Sherman Act violation as opposed to Section 1. Section 1 is if you simply clear the horizontal marketplace. Section 2 is, yes, it can be shown to be a monopolistic Sherman Act violation. You have to show an anti-competitive harm. So you have to show a harm to the consumer. So in a legal case, the burden would be on us to show that the consumers are paying a markedly higher price. Now, we're in a political arena, so we don't need to show that. We just need to convince you. Again, we've done cost analyses, which we're happy to share, and I think we will once we get to the session, which show that there are higher prices paid when you have a vertically integrated market. But in terms of a Sherman Act violation, it would be a Section 2, so it would be more of a rule of reason than an automatic per se.
Mr. Chairman, I was trying to get at what I was getting at. Centera owns Optima, I believe it was something like that. And so you were saying that the members on the board of Centera are also the members on the board of Optima, and they can decide on whether or not Optima can take other patients through other insurance. Is that my question? Mr. Curtis, is that what you're trying to say? That's my first question. I'm trying to figure out these two boards, because you were saying Centera owns Optima, and the same people say we're on the same board, and they can say to, can you explain that part to me, please?
Mr. Chairman, Senator Spruill, I'm not suggesting that they do have the same boards. I'm simply saying that they should not be permitted to have the same individuals serve on both boards at the same time.
Okay. Mr. Chairman, second question. Then the second question, so you're saying by doing that, by having the same person on the same board, then they could tell Optima, no, you can't receive this person and that person or this insurance. I'm trying to figure out what's the problem by having the same person on the same board. What are they doing? What they could be doing wrong?
Mr. Chairman, Senator Spruill, again, I go back to when I was answering Delegate Gudaitis' question. It was clearly stated to us in a meeting that by the head of Optima, Mr. Mathis, Dennis Mathis, that his parent company directs him, prohibits him from allowing certain types of providers in the Optima network. And specifically those that are, and I'll give you, no need for example, but just to say that you can have these kind, but you can't have these kind.
That's right there.
So that's where we want there to be a firewall so that the insurance company is operating on its own direction by its own governance board for what's best for its members, not its parent company.
Mr. Chairman, then that's my question. Then my question is, away from Centera, then how can we make it without a firewall? How can we make it when Optima's board on its own without getting direction from the other company saying what they can and cannot do? So my question is that how can we make it that Optima can be an independent board, even doesn't matter whether the same members or not, but they can make a decision and not let a parent company says to Optima, no, you can't do this, yes, you can do this, but do it on your own. Am I making sense? I want them to be able to have their own decision making without someone telling them what they can and cannot do. That's where we're at.
Mr. Chairman.
Yeah, Senator Searle.
I have one more question for Mr. Byrd. So can you give me an example of something that, if we remove this language, something that the board could do that's not prohibited by the other sections we'd be changing? Because like this other, the other sections have all this stuff in here about, pricing and benefits and, offering services and all that. I'm just trying to understand exactly. I get the potential conflict of interest. I'm just trying to understand exactly what additional thing that the board could do that's not prohibited by this, so that by removing the language, we open the door to.
Mr. Chairman, Senator Servell, no. Again, we are open to the bill in its totality and how it can best impact consumer choice, price, that sort of thing. Our belief is that as its own entity with its own governance structure in this particular issue that we're talking about, that it should operate as such without any influence by its parent company by way of shared membership on its boards.
Mr. Chairman's last statement, I guess. And I get that, but I think in the other plans that we have around the state, there's probably, I don't know for sure, but there's probably overlapping directorships between the boards, but I guess from your perspective, that's mitigated by the fact there's other investors in the plan that have different interests, and that potentially mitigates that. I'm just trying to figure out the policy that we're pushing for this situation and how that squares with the broader policy that we have Commonwealth-wide. But anyways, I appreciate the feedback.
Yes, and Mr. Chairman, again, this is really not the crux of the bill. As Senator Peterson said, what really is at play here is the any willing provider. So at the end of the day, if this body does not have consensus that this is an important piece of what's being brought forward, certainly it is not something that we would go forward with.
Mr. Chairman, and just, you can tell I'm unclear on this. I mean, if the bill advances on any willing provider, doesn't that tend to negate any mischief?
I would think so. Thank you, Mr. Chairman.
Good morning. I'm Anna Healy-James with Centera. Just to clarify, this would set a precedence of dictating from the General Assembly who is on what board and why and what they can do in the boardroom. And as a reminder, we're a not-for-profit, private not-for-profit. So I'm just saying this would set a precedence for the General Assembly taking that step into that. So I just want to put that out there.
Chairman, yes, Anna. So you were saying, are you in favor of this?
Yes, so taking
thank you.
This provision out. Thank you.
All right. Is there anyone else who wishes to speak on this issue?
At this time, would any members of the public in the Zoom room who have signed up to comment virtually, please use the Zoom raise your hand feature if you would like to speak to this specific motion. James Sherlock, I'm promoting you to panelist now. And Mr. Sherlock, for clarity, did you wish at this time to read your prepared remarks or to speak to the specific motion before the body? James Sherlock, are you there?
How about now?
Yes, I can hear you now, Mr. Sherlock. Did you wish to read your prepared remarks at this time, or are you planning on speaking to the specific motion?
Having listened to the questions, I'm going to revise my remarks slightly in order to directly answer some of those questions as well as present what I have to say.
Right now, Mr. Sherlock, we're just interested in discussing the motion before the body specifically. And there will be a period of public comment after this where you can read your prepared remarks.
Well, it's up to you. I'm prepared to address the panel and answer their questions.
Go ahead, Mr. Sherlock.
Okay. Centera is by far the largest vertically integrated healthcare business in Virginia. I have studied it, and I've studied Innova and some of the others using their Forms 990, their IRS annual reporting, as well as their annual consolidated financials. Centera Healthcare, the holding company, reported total assets of $8.4 billion in its June 30th, 2019 consolidated financials. The system itself, as reported to the IRS, was composed of 63 companies, including 20 not-for-profit organizations, 21 taxable partnerships, and 22 taxable C corporations. Each filed its own federal and state returns. I stand in support of Senator Peterson's bill, and I think you'll see why. The study that you were presented missed what I considered two issues concerning vertical integration at Centera, one of which is addressed in the bill, the lack of effective independent internal board governance, and one which is not, which is of great concern to this panel, which is the lack of effective state regulation and oversight of such vertically integrated organizations. Centera Healthcare and its largest operating companies pay no taxes. The state in return has an obligation to the taxpayers to oversee that company to ensure that public interests are served. It does not do so effectively and never has. Centera corporate board structure by design lacks the span of control to provide independent governance to its operations. The independent board governs the holding company. The 62 operating company boards, including Opera, are staffed by Centera executives. Those executives' compensation includes bonuses based on the profitabilities of the companies they run. The state is unable to efficiently and effectively oversee Centera because the Commonwealth's own segmented regulatory structure cannot deal with Centera's integration. Neither the State Corporation Commission nor the Department of Health is in a position to fully regulate and oversee Centera. The Department of Health oversees the practice of medicine, but not, with the exception of COPN, the business of healthcare. SCC oversees to a limited degree the business of health insurance, but not the business of healthcare. Vertically integrated Centera Healthcare thus has neither independent internal governance nor effective state regulation and oversight. In this environment, Centera's Optima and Virginia Premier control more than half of the state's Medicaid managed care population. No one outside the company can look in to ensure the public interest when Centera's Optima negotiates prices behind closed doors with Centera's hospitals and physicians. No one outside the company is in a position to judge the difference in Optima payment schedules and networks between Centera providers and competing providers. You have just to look at the Centera Healthcare Form 990 to see how many hundreds of millions of dollars are moved annually from Centera's operating companies, including Optima, to the holding company and from the holding company to other operating companies. Profits are a shell game under that structure. You have the opportunity with the legislation under consideration to begin to assert the public interest. First, the bills being considered will make a huge positive difference if they require restructuring of Centera to establish independent board governance among the hospital, insurance, and physician components of the organization. Without that, there is no firewall. Second, if such vertical integration is permitted to continue to exist in healthcare in Virginia, and I personally recommend that it be banned, the Commonwealth will have to figure out how to regulate and oversee it at the same level of integration as the corporations themselves. That concludes my remarks. I'll take your questions.
Mr. Chair, a quick question.
All right, Senator Servo.
Thanks. Mr. Sherlock, you're the same guy that blogs on Bacon's Rebellion, right?
Yes.
Okay, great. I just want to make sure I don't see your face. I want to connect that dot. Thank you.
Mr. Chair, at this time, there are no further members of the public to comment.
Any further discussion or questions, comments? All right, do we want to take action on this motion now?
Mr. Chairman?
Yes, Senator Servo.
So I think I made the motion. I think I heard Senator Spruill second it, so I think it's before us. I mean, it sounds to me like it helps us get closer to peace in the valley, although I don't think we'll ever get to peace in the valley. So, and I haven't heard anybody that's really strongly advocating to keep the language, although strongly advocating for it. So, I mean, it just seems to me this is helps a little bit. So, I'll support my motion.
All right. We're shocked, but all right. The motion is before us. You want to
Voice or roll by your choice, Mr. Chair.
All right.
Mr. Chairman, just to clarify, if the Commission would like to strike lines 174 through 177, there would also need to be a change made on lines 219 and 220, striking and subsections R and S, or striking subsections R and S and inserting subsection R.
So moved, or make a friendly amendment to my amendment or something.
All right. Okay, it's been amended. Is there a second to that amendment? Second. All right. All in favor of the amendment to incorporate it in with the rest of the other lines to be stricken, say aye. Aye. Opposed, no. All right. And now we'll go on to the motion if there's no further discussion. No. We're just dealing with your motion, which has now been amended. So it's striking lines, what is it, 174 through 177 or whatever. And then the 219, I guess, and the other amendment. All right. All in favor of that motion, say aye. Aye. All opposed, no. All right. We've dealt with that. All right. Are there without any other proposals at this particular time, we can proceed to public comment on things.
At this time, I'd like to ask any members of the public here in person who wish to provide general comment to the Commission, please step forward to the lectern.
Good morning, Mr. Chairman, members of the Commission. My name is Lee Nussbaum, and I am a constituent of Senator Spruill's, a longtime former aide, and it's nice to be back in Richmond. I'm also a grad student in New York, but as you all know, I've been here many times before. I wouldn't be standing here without IVF. It's certainly not something that women dream about. My mother certainly didn't. But the fact is that infertility is a disease. That's not a turn of speech. It's a definition by the American Medical Association. It affects about 1 in 8 couples in the U.S., and these could be your family members, your friends, your colleagues, and almost certainly a percentage of each of your constituents. And for women that are in my age range, I'm 32 now, fertility rates start dropping. I don't know what caused my family's infertility, but I won't deny that I struggle with a lingering fear that I might also struggle to have children one day when I am ready. I don't want to undergo IVF unless I have to, but I also don't want to worry that I either have to put myself or my family under financial strain. And so ultimately, I feel like, Mr. Chairman, members of the committee, that the question we're asking is, when we look at this issue, is whether having a baby is a right or a privilege. That is, does it fall under the ability to remedy ways that a body malfunctions? We've been talking a lot about costs as we've been through this commission meeting over the year, but I'd want to ask if you could put a price on preventing serious depression and anxiety, decreasing stigma around female and male infertility, and saving marriages. The fact is that infertile couples are 3 times more likely to divorce, and ultimately putting the price on a new addition to a family, a child. So just here to continue the call and hope that you guys will consider legislation around IVF coverage by the end of this year. Thank you.
Next.
Mr. Chairman, members of the Commission, just some general comments on the issue. Senate Bill 867 and vertical integration. On August 31st, two experts in the field of healthcare delivery presented to this commission their white paper about vertical integration in healthcare and how it can adversely impact healthcare consumers. And I don't really want to get into the specifics of that because I know you all have gotten a copy of it, you've read it and familiarized yourself with it, but there are a couple of just important points I want to put before the commission as you ponder this issue. First, there is an inherent conflict of interest when a hospital and an insurance carrier are under common ownership. There is an incentive to abuse that relationship by using the insurance company to hurt providers and to use the hospital to hurt competing insurers. In fact, earlier this spring, one of the vertically integrated systems threatened to terminate its hospital participation in a competing payer's product. And that ultimately was withdrawn, but it just goes to show you that it can be used very, very adversely. So this leads really to the findings of the white paper, and that is that when power is concentrated in a vertically integrated system, prices do go up, and quality, frankly, is stagnant, or maybe even worse. So the problem can be solved, and we've been talking about the any willing provider issue. That is a law that was enacted in 1983. Since then has had no other than just some technical cleanup, has not been addressed at a time when healthcare delivery in the last 40 years has changed dramatically. And so we are not advocating for the mandating of rate terms or anything like that. We're just simply asking the Commission to support the white paper's recommendation back to the legislature to plug that gap that's in the any willing provider statute today. And so we're looking to have today's any willing provider language to allow and include ambulatory centers. Those are the lower cost facilities that consumers need today. In a time when high deductible plans are kind of the norm, people need the option to go someplace where it's not going to cost them everything that they have. In fact, I would suggest that potentially the choice would not come down, or the choice could come down to whether the procedure is done at all. And it's all because of the economics of it. So again, we've talked about other issues surrounding it, but I think it's important to say that with the changes in healthcare, I think a modernization of the existing any willing provider statute is in order. So thank you very much.
All right, any questions?
Mr. Chairman, quick.
Yes, Mr. Berg, got a question here from Delegate Heretic.
Not necessarily for the speaker, Mr. Chairman, but
okay.
having lost the patron, I see, does the Bureau of Insurance, is anybody here from the Bureau of Insurance?
Yes, there's Bradley Marsh. Oh, pardon me, State Corporate.
If I could just ask out loud if the Bureau of Insurance has any. Oh, sorry about that. I know it's been buzzing. I was wondering aloud, speaking in response to the gentleman's comments, if the Bureau of Insurance has any particular comments or viewpoints about adding ambulatory care facilities into as an expansion of the bill potentially.
This is Scott White. I'll let Julie answer if she has information, but to my understanding, we don't take a position on this particular provision. We just want to make sure that we can properly administer it, and I think we could do that.
Thank you.
Thank you, Mr. Chair.
I would agree with that.
All right, thank you, Julie.
Good morning, everyone. My name is Tiffany Jefferson, and I am here to pledge my support for HJ 545, insurance mandates for fertility treatment as well as fertility preservation. Infertility is a disease that is commonly associated with shock, disappointment, embarrassment, shame, and silence. So I speak today for those who are silent, the men, women, and people of the state of Virginia. Infertility does not discriminate. My husband and I have been diagnosed with the disease of infertility, and our infertility is caused by a hormonal imbalance that affects our reproductive functions. Our doctors have told us that there is little to no chance that we would be able to achieve a pregnancy on our own without the medical assistance of in vitro fertilization. Our insurance coverage does not provide coverage for this treatment, although we pay upwards of $500 a month for health insurance. IVF could cost upwards of $25,000 out of pocket. This is not fair, and it does not represent equality for all. Fertility treatment should not only be accessible by the rich, wealthy, or celebrities. More and more middle-class millennial couples like us will need assistance because we were not taught about fertility, and we are waiting longer and longer to begin our families. As a matter of fact, there are 19 other states with mandates and many others who are working on it. Infertility, it causes depression, anxiety, and it destroys relationships. The holidays like the ones coming up are even harder, as we have to prepare to be asked, when will you have children? Well, I hope that with the passing of HJ 545, I can tell them that the first baby will arrive in 2022. Virginia is for lovers, and the lovers would love some babies. There is a lot of discussion about how a fertility treatment mandate could hurt Virginia financially, but I beg to differ that it will have an opposite effect. People who need fertility treatment are seeking out places to live and employers who provide family-friendly benefits. Virginia has the opportunity to be one of those great places and show us how much this state truly loves and values its people and its families. Thank you so much, everyone, for your consideration.
At this time, I'd like to ask that all remaining persons in the room who wish to provide public comment, please line up behind the lectern so that we can get a sense of how many there are.
Hello again, Anna Healy, James Centera. Just want to, as we talk about the integrated delivery network, that's what we call it, the vertically integrated bill, I just want to remind you of a few facts. First of all, the lowest premiums in the state are actually in Hampton Roads because there's actually robust competition between Anthem and Optima. And so we drive the premiums down for our consumers and for our members. And so that is the value that we bring for that true competition. In order to do that and to actually be competitive against Anthem and other health insurers, Centera cannot pay itself a lot of money, because how else would you keep the cost down? So I just want to remind you of that. The second thing I want to remind you is that we've always had Chesapeake Regional in the Optima network since the inception in the early 80s of Optima. They have never not been a network. And even as of this year, we do cover all of their ASCs and all of their imaging. So everything is covered within Optima's network with Chesapeake Regional. So we just want to remind you of that. In addition, with what we call an integrated delivery network or vertically integrated care, this bill would go against that and substantially raise healthcare costs. So Mr. Byrd originally said it doesn't set rates, but in essence it does set rates within the bill. It creates an uneven playing field amongst Optima and to other for-profit out-of-state health insurers, Anthem and others, because we are the only Virginia-based not-for-profit health insurer in the state, and this only affects us as well as Virginia Premier, which we own 80% of, which is Medicaid, mostly Medicaid. It also sets a precedent by mandating these rates with providers, and it can also potentially harm our members by having us have providers in our network that aren't the highest quality and standards that Optima and Centera want to have within our quality care networks and other opportunities that we have to really drive volume to high quality providers. And so that's our concern with this bill. And happy to answer any questions and look forward to more discussion on this.
Mr. Chairman,
Yes, Delegate Goditis.
I wonder if the speaker could just remind me what ASC stands for.
Oh, ambulatory surgical centers. And so they're kind of outpatient surgical centers. Thank you for, I know healthcare is all of its acronyms.
Mr. Chair, turning now to our virtual Zoom room and public comment there. I'd like to remind our attendees in the Zoom room, if you are presently in the Zoom room as an attendee, you have registered to provide public comment. All attendees in the Zoom room will be called upon to provide their comment. If you do not wish to comment, exit the Zoom room now. Return to the Virginia Senate live session video stream webpage and click on the link that reads View Event next to the meeting name. We'll begin with Elizabeth Carr, who I'm promoting to panelist presently. Betsy Campbell, you will be next. Elizabeth Carr, whenever you're ready, please unmute yourself and begin your comment.
Thank you, committee chairman and committee members. I'm Elizabeth Carr. I'm from Swansea, New Hampshire, but I was born in Norfolk, Virginia, and I'm representing myself as well as those navigating an infertility diagnosis. The reason I support this, of course, is inherently personal. If my name seems familiar, it's because it has a place in the history of the state of Virginia. Nearly 40 years ago, I was born the first in vitro baby in the United States at what was then Norfolk General Hospital in Norfolk. I'm in support of this because people should not have to fight as hard as my parents fought to have me. They were part of the 1 in 8 experiencing infertility. I am a product of my parents being able to beat the odds thanks to access to a technology that no one had really come to understand yet. You see, nearly 40 years ago, when my parents were given the devastating news that they may never have children of their own, and they were trying to figure out what to do, it was in Virginia and found hope. There was a program pioneered by Drs. Howard and Georgiana where they were setting out to have the first success with in vitro in the United States after learning about success in England just a few years previous. My parents, who were living in Massachusetts, flew to Virginia every month for my checkups. Why would they do such a thing? Let me remind you that IVF at the time was unavailable and inaccessible to my parents' home state in Massachusetts. And so Virginia truly gave them an option when they didn't think they had any options at all. Lack of insurance coverage for infertility medical treatments is a major barrier to family building. Having children is fundamental. It's part of one's identity. Being unable to have a child affects people physically, financially, and emotionally. My parents experienced setback after setback. Due to ectopic pregnancies, my mother nearly died 3 times, and a simple pamphlet handed to her by her OBGYN provided the last glimpse of hope that they could cling to. If the state of Virginia had not been a pioneer and visionary nearly 40 years ago, I would not be here today. I urge you to support this. I have great pride in calling Virginia my birthplace, and I want to be able to continue to tell the people the story of how Virginia laid the foundation for reproductive history and so many options long ago. I truly hope I do not have to wait another 40 years before everyone has access to the care that they so deserve. Thank you.
Betsy Campbell, when you're ready, please unmute yourself and begin your public comment. Craig Connors, you will go next.
Thank you. I'm Betsy Campbell, Chief Engagement Officer for Resolve, the National Infertility Association, headquartered in McLean, Virginia. Resolve represents the millions of women and men in the U.S. with the disease of infertility and the more than 250,000 Virginia residents who struggle to build a family. I would like to address HG 545 and start with reading a letter from Kate Zickel from Alexandria, Virginia, who is sick and unable to testify this morning, but asked me to read the following. Good morning. Thank you for hearing me and 1 in 8 women with breast cancer today. My name is Kate Zickel, and I have survived breast cancer twice. Because of cancer, I will never have children. Cancer has taken my fertility from me in a way I never expected. Initiatives like this give me hope because it means women like me have options. We would have the opportunity to make our lives fuller, to start from square one rather than from behind. As you know, fertility treatment is debilitatingly expensive. Most women cannot afford it, and that's without tens of thousands of dollars in oncology and gynecology treatments. Delegate Helmer's quote is accurate. Children are a joy that women like me may never know without the support of this initiative. Thank you for your time, Kate Zickel. And now I'd like to speak briefly on behalf of Resolve. Across the political spectrum, from New York to Arkansas, 19 states provide benefits for fertility treatment, some for decades, including Maryland. These states recognize that infertility is a disease and should be covered by private insurance like other diseases. As you just heard from Elizabeth Carr, Virginia led the way in pioneering IVF to treat this disease. The Jones Institute for Reproductive Medicine had the first IVF program in the U.S. and the first IVF baby born in this country in 1981, Elizabeth Carr. In addition, groundbreaking research in 2014 by EVMS's renowned physician, Dr. Howard Jones, estimated that the national savings from fewer multiple births resulting from IVF insurance coverage would be over $6 billion a year. When patients do not have coverage for IVF and must pay out of pocket, they are more likely to transfer multiple embryos. Studies show patients in mandated states were more than twice as likely to have elective single embryo transfer. This means that insurers could potentially save tens, if not hundreds of millions of dollars a year by providing IVF coverage. So when we talk in terms of defrayal costs, let's also keep in mind the cost savings. And most importantly, the result is healthier babies and moms. Maryland recognized this more than 35 years ago, becoming the first state to cover IVF. And since then, they have expanded the mandate 5 times to make it more comprehensive and inclusive. This puts Virginia at a serious competitive disadvantage with reproductive age residents, many of whom can easily move to Maryland to gain more attractive fertility care benefits. In the past 6 years, 8 states have passed new or expanded infertility insurance laws, and 11 states have passed new fertility preservation laws since 2017. Not one has been required to defray the cost, and Resolve is happy to work with Legislative Council to develop language to protect the state against potential defrayal. We urge HERC to study mandating insurance coverage for infertility treatment in 2021 to help Virginians like Kate Zickel build their families. Time is not on the side of infertility or cancer patients. This cannot wait any longer. Helping Virginians build their families is something I think Democrats and Republicans can all agree on. As Governor Sununu of New Hampshire said upon signing similar legislation in 2019, including these benefits in healthcare plans will help retain young workers, a goal we should all be supportive of, unquote. Thank you.
Craig Connors has left the Zoom room, so we are skipping ahead to Steve Morton. Steve Morton, whenever you're ready, please unmute yourself and begin your public comment. Our final speaker today will be Sharon Nussbaum. Steve Morton has also left. I'm promoting Sharon Nussbaum now. Sharon also seems not to be available. Mr. Chair, that concludes our period of public comment.
All right, thank you. Are there any other issues anyone wants to bring forward at this time? All right. Let me sort of go over where I think we are in terms of the situation related to the Senator Peterson's bill, 867 there. We talked at an earlier meeting about establishing a work group, and I think that we can proceed in that fashion to put together a work group to address what I think are the most significant issues that we need to deal with in terms of moving forward and hopefully reaching some consensus on things. I would point out that the paper that had been submitted basically on behalf of Chesapeake Hospital, on the pages 3 and 4, there are 4 issues that are identified there relating to impacts upon insurance networks, upon other hospitals in an area, on ambulatory facilities, and on physicians who are not part of the integrated network. And I think those are the fundamental issues that we need to deal with and see what we can come up with moving forward there on that. And with that, I would basically recommend that that's how we proceed at this point. There have been several people who have volunteered to work on the work group, and I think that we can get started as soon as we can on that and move forward and try to get to reach consensus on things. Are there any other suggestions or comments from other members on the commission? All right.
Chairman?
Yes, Senator Sproul.
So the motion that was made by Scott Survey, so what are we going to do with that?
That was passed, so that motion would be moving forward, that would not be something that we would want to incorporate in a bill there.
So we have a work,
stricken.
this is what you recommend is a work group?
Yeah, so we're going to try to build a work group and work on it that way and try to get the stakeholders involved and see what we can do in terms of reaching consensus on things. I think this is a significant issue, but I think we need to make sure to try to get everybody on the same page as best we can.
Mr. Chairman?
Yes, Senator Servo.
Is the objective to reach a consensus before the next HERC meeting?
I'm not sure that we'll be able to do it that quickly because that is, less than 2 weeks away. But we will try to move forward as quickly as we can on things.
Mr. Chairman?
Yes.
Is the objective to reach a consensus before next session?
As quickly as we can, and it may be before the next session, but it may not. I'm not sure whether we'll be able to get everything done by then. So,
Mr. Chairman, you sound like a lawyer. That's not the answer to the question. You sound like a lawyer now. You didn't answer the question.
Senator Sproul, you know quite well I'm not a lawyer, so.
I think what he's saying is we've got a Herculean task if we think we're going to get everybody on the same page on this.
Yeah. All right.
Well, Mr. Chairman, one other thing.
What's
Other
that?
comment, I would just note, in light of the new bill limit and the Senate rule, if this commission were to take some sort of positive action, even if we really didn't mean it, it might not count towards somebody's bill limit.
Yes, spoken by motion by somebody who's impacted. So.
Some of us never hit our bill limits, though. There are others who, have to worry about bill limits.
Yes. All right. Is there anything else anybody has to bring to the good of the order here? So, all right. Is there a motion to adjourn? All right. We've got a motion and a second. All in favor, say aye. Aye. All right. Opposed? We are adjourned. Thank you.